those rules also applied here in the movable property. Of course, the next remedy is the right to ask for specific performance or fulfillment of the contract in the case the seller has failed to deliver the thing. The buyer can ask for specific performance or fulfillment. So now, what if the seller has committed a breach of warranty? The following are the remedies of the buyer. So, breach of seller's warranty under Article 1599 of the Civil Code, where there is a breach of warranty by the seller in the sale of goods, the buyer may, at his election, avail the following remedies. So, there are four remedies. First, accept or keep the goods and set up against the seller. The breach of warranty by way of recoupment, indemnification, or extinction of the price. Second, accept or keep the goods and maintain an action against the seller or for the damages for the breach of warranty. Third, refuse to accept goods and maintain an action against the seller for damages or breach of warranty. And lastly, uh, rescind the sale and refuse to receive the goods. If the goods have already been received, you must return them or offer to return them to the seller and recover the price or any part thereof which he has been paid. Now, there will be no rescission in the following cases. So there are two scenarios which will be which there is no rescission. So first, if the buyer accepts the goods, knowing that the breach of warranty, but he did not protest. Second, in case of the buyer fails to return or to offer the return of the goods, the condition that they were at the time of the delivery to him. Because of course, in case of rescission, there's a duty of a mutual restitution, and the thing must be returned substantially the same condition what it when it was start of the relationship. Um, Second is, what are the effects if the rescission is chosen? So the buyer will cease to be liable for the price, but he is no longer liable for he is not longer liable for the price. He can now return the goods to the seller and now recover the price. Furthermore, he can now or he the buyer, if he has the possession of the goods, he can hold the goods as a bailey if the seller refuses to accept them, and finally has the lien on goods until he received the full recovery of the price that he has paid. Now, let's go to the other remedy of the buyer. It talks about sample or sale by description. In case by a sale or sample, then the buyer may ask for the rescission of the contract or cancellation of the contract if the bulk of goods delivered to him does not correspond to the sample, which was to show which was not show which was shown to him. Furthermore, for the case of description, rescission is also available. If the goods do not correspond to the description, but what what if the sale is both by sample and both by description? And so rescission will be available if the goods do not correspond um, both sample and the description. It has to be both. And now we are in our last discussion. It is about the extinguishment of the contract of sale. We are done discussing the remedies of the seller in case of immovable, also to the remedies of the buyer, and it is also from immovable and movable. Now, let's begin in the extinguishment of the contract of sale. Remember that the contract of sale is a special contract and as such subject to the general rule on the obligations and contracts. Um, we are all aware, or we are all have a background in obligations and contracts. As a consequence, a contract of sale by extinguishment by the same modes of extinguishment of obligation, namely payment of performance, or loss of the thing due, condemnation, compensation, novation. Also, we have rescission, annulment, fulfillment of resolutory condition. So those are the common causes. It is under Article 1231 of the Civil Code. And now we have special rules in extinguishing of a contract of sale. Now, those rules are scattered in the provisions of law of sales. They mostly come under the topic of rescission in 1484 or recto law. There are also two special modes of extinguishment, which are the conventional redemption and legal redemption. Those we're going to discuss. And more importantly, under Article 1600 of the Civil Code, sales are also extinguished by conventional or legal redemption. Redemption as mode of extinguishment is therefore unique to the contract of sale. So now, as we've mentioned, the two modes of extinguishment, first we will discuss the conventional redemption. So what is conventional redemption? So conventional redemption shall take place when the seller reserve for himself the right to repurchase the thing sold with the obligation to, we have four instances. First is the return, the price of the sale. Second, the expenses of the contract. Uh, Third is any other legitimate payments made by reason of the sale. And fourth is in the necessary and useful expenses made of the. Even when a sale is won with the right to repurchase, the buyer would still be subrogated to the seller's right and actions even during the period when redemption can be made by the seller. In other words, the redemption or feature of sale does not prevent its full consummation. So there are seven instances, or there are seven following cases when a sale with conventional redemption is deemed to be an equitable mortgage. So there are seven. First, unusually inadequate purchase price. Second, possession by the vendor remains as leasing or otherwise. Third, extension of redemption period after the expiration. Fourth, retention by the vendee of a part of the purchase price. Fifth, vendor binds himself to pay the taxes of the thing sold. Sixth, any other case where the parties really intended that the transaction should secure the payment of a debt or other performance of any obligation, or lastly, when there is a doubt as to whether a contract is a contract of sale with the right or repurchase or an equitable mortgage. So, what is equitable mortgage? One which lacks the proper formalities, form of words or other requisites prescribed by law, or but shows the intention of the parties to make the properly subject the contract as security for a debt, and contains nothing impossible or contrary to law. Uh, or can there be a presumption as to equitable mortgage? So there are there are there are some following scenarios. Parties must have entered into a contract denominated as a contract of sale. Second, the intention of the parties was to secure an existing debt by way of mortgage. Please, it is important to take note that in cases referred in to Article 1602 and 1604, the apparent vendor may ask for the reformation of the instrument. So they call the remedy of reformation. It is to correct the instrument so as to make it express the true intent of the parties. Let's talk about the redemption period. If there is an agreement, period agreed upon exceed 10 years, if no agreement as to the period, 4 years from the date of the contract. Third is if the vendor who fails to repurchase the property within the period agreed upon may, however, exercise the right to repurchase within 30 days from the final judgment. Final judgment was rendered in a civil action on the basis of the right to the contract was a true sale with right to repurchase. Those are about the more conventional conventional. Uh, let's move on to the legal redemption. The right to be subrogated upon the same terms and conditions stipulated in the contract. In the place of one acquires a thing by purchase. A second is by dation in payment. Third, or any other transaction whereby ownership is transferred by owner whose title. Legal redemption may be effected against movables or immovables. So, what are the basis of legal redemption? Not on any propriety right, which after the sale of the property and execution leaves the judgment debtor and vest in the purchaser, but on the bare statutory privilege to be exercised only by the persons named in statute. Tender of payment is not necessary. Offer to redeem is enough. So there are instances of a legal redemption. It can be divided into two. So under the civil code and the under special laws. So let's discuss about the under the civil code. First, sale of co-owner of his share to stranger. It can be seen in Article 1620. When a credit or other incorporeal right in litigation is sold under Article 1634, sale of an heir or his hereditary rights to a stranger under Article 1088, sale of adjacent rural lands not exceeding 1 hectare under Article 1621, and lastly is the sale of adjacent small urban lands brought merely for speculation under Article 1622. Under special laws, on the other side, is an equity of redemption in case of judicial foreclosure. Second, a right of redemption in cases of extrajudicial foreclosures. Third is the redemption of homesteads. And fourth is the redemption in tasses of sales. And lastly is the redemption by an agricultural tenant of land by the landowner. So those are the topics that we discuss about the extinguishment of the sale. So those are the rights of the seller, rights of the buyer, and extinguishment of sale. That's it. And have a good night. Thank you.